It's with much pleasure that I introduce our next guest, Professor Patrick Keyzer. We've had a bit of an association. We haven't got conference proceedings from this because that was a little bit of a challenge to organise, but we do have it being videoed and it will be captioned and it will be on both the NDS website and the Endeavour website, and I presume the website of the other partners for this. But the Community Advocacy Support Units Association with Patrick went back to a Practical Design Fund grant for the National Disability Insurance Scheme. And what we did include in your lovely little orange bag was a copy of the Discover Guide to planning for a future with people with disability. And why it was relevant today was because when we did focus groups in every state and territory with family members and with people with disability to plan this resource for people, people said there was a lot of information about planning from a future that they wanted, which wasn't necessarily planning for the National Disability Insurance Scheme. So Patrick at that point was the Director of the Centre for Law, Governance and Public Policy at Bond University, and together with Veronica Jones and Gail Casey, they collaborated with the CAS unit to produce this. And there's a lot of stuff in here that's relevant to our discussion around capacity, guardianship, powers of attorney, etc. So we thought it was worth as a resource, but also it's just a great resource for anybody in the sector around planning around people with disability, including perhaps involvement with some legal issues. Patrick since then has moved, as you can see, to be Professor who's head of Trobe Law School and Chair of the Law and Public Policy Unit there. And he's going to be talking on the intersection between the UN Convention on the Rights of People with Disability and the Queensland criminal justice system. So it's over to you, Patrick. Thank you very much.
Thanks, Mark. Hi everyone. Just going to make sure the clicker works. Yep. All right. Well, thank you, Mark, for your warm welcome. I'd like to congratulate Mark and his team for putting together today's event, which I think is a very worthwhile thing to do. I'm pleased to be working with Mark and his team again. We, as he mentioned, I was involved in this exercise, and if you haven't seen it, I commend it to you. It's a little bit out of date now, but you might find it useful. That was a hint, actually, for an update, just in case.
No, we're renegotiating.
I'd like to join the people who spoke before in acknowledging the traditional owners of the land and the elders, past, present, and future, and thank in particular Muru Kuchin, who engaged in what I know you will agree was an utterly enthralling welcome to country. I was transfixed personally, and I wish her and her people the warmest best wishes with their native title claim. I hope in particular that their claim encompasses a number of government buildings in Queensland, and if they can effect a takeover, I think that would be a very good thing. I'd like to thank the Public Advocate Jodie Cook for her very informative address, which helps set the context. Like Jodie, I'm an eternal optimist. Well, maybe just an optimist these days. I must confess that when it comes to international law and its capacity to provide justice here within Australia, I have, by dint of bitter experience, become a bit more of a realist, and I think that will be reflected in my talk today. But Jodie's comments about the need for a solid evidence base, the importance of justice reinvestment, the complicated reality of Queensland legislation, which I've recently left behind for the complicated reality of Victorian legislation, and the need for the building of community are points that were very important for setting the context today. And I'd like to acknowledge the many outstanding scholars and advocates who've come to today's event. And I want to develop some themes in this talk. about people with cognitive impairment or impaired capacity. I'll just use those expressions loosely. I'm not going to engage in the obligatory academic exercise of defining categories for an hour and then not saying anything of substance, although you may reach the conclusion at the conclusion of my talk that I didn't say anything of substance, so you might just reach that conclusion. But I have found that as I moved from Queensland to New South Wales and then Victoria, my sophistication as an academic has increased as I go south, I just wanted to briefly mention for David Barbagallo's benefit, just in case he sees the video, that I'm a blues fan, a blues supporter, and sucked in Queensland. Is all I can say. Sucked in. It's about time. My son's 9. He didn't remember the last time we won. I assured him that it does happen sometimes, and I'm just very pleased that it happened last night. So sucked in Queensland. Right. So I think these themes have been picked up on by previous speakers, and none of this is going to be new to you. But we need a national approach to this issue. We need an informed approach. We need a uniform approach. I don't think that the United Nations Convention on the Rights of People with Disability is going to be making a critical difference. I'm sorry to say that, even though I think that the values expressed in that document are absolutely critical. And we need national political leadership. And at the conclusion of my talk, I'm going to be laying down the challenge on that. Now, I'm just going to start and spend a few minutes touching on some issues that are likely to be addressed by other speakers. The people who are speaking at this event over the next 2 days, it's really a who's who of research on these topics, on the intellectual disability and the criminal justice system. And I'm anticipating that they're likely to talk about the sorts of things that they usually talk about and that you can read when you are reading their literature. So I'm not going to dwell on those things. I'm just going to touch on some of the key contextual issues that are raised by those researchers. And I apologise, incidentally, if I've overlooked any people in this room whose research is also excellent. It's a bit of a grab bag approach. It's not trying to take a comprehensive approach here, just identifying a number of the key issues. And then I want to talk in a bit more detail about something where I've had a little bit more involvement, and that is the Aboriginal Disability Justice Campaign. So if you haven't heard about that, I'm here to tell you about it. And if you have, then you can correct me at the conclusion of the talk. Well, we all know that the Australian Human Rights Commission has been active in this space, and we're looking forward to hearing from Graham Innes tomorrow morning. We know that in February they published their report on equal before the law, and that the report highlighted the various ways in which equality before the law is not afforded to people with disability within the criminal justice system. The report recommended the development of a holistic overarching disability justice strategy, and the Australian Human Rights Commission is of course active in that space, and there have been a number of publications since the February report, and you'd all be aware of them. So I'm not going to repeat them, and Graham will be speaking tomorrow, so I only mentioned that as a point of context. Now, I just want to isolate one thing that Graham said in the introduction to that report, though, because it is a theme that I want to come back to in the talk from time to time. And these are Graham's words. I appreciate that criminal justice is primarily the province of states and territories, and for this reason, they've taken the approach that they've taken in that report, seeking to point out the barriers, highlight services and programs, and propose possible actions towards the development of disability justice strategies. I trust that this approach will be a benefit to state, territory and Commonwealth administrations in their ongoing work. Now, I just wanted to touch on that and say, and I'm quite happy to say this to Graham tomorrow. I'm sure there were reasons why he said this in the introduction to the report, but I appreciate that criminal justice is primarily the province of states and territories, but in this area it just shouldn't be. We need a national approach in this area, and I'm going to be developing the reasons why. And it's they're the same reasons why we have the National Disability Insurance Scheme, because the state and territory systems are just too fragmented, they're too different. We just didn't get the sort of results that we needed over the last 30, 40, 50, 200 odd years in dealing with this issue by having state and territory systems. And that doesn't mean that there aren't people at the state and territory level who aren't doing a wonderful job, including a lot of the people in this room, at doing a fabulous job. However, there's just too much variability in the system, there's too much fragmentation, and that's why the NDIS emerged, and that's why it really attracted such strong support and bipartisan support, because there was a recognition that the system was broken and that there needed to be national changes. And frankly, I teach constitutional law. I've been writing in that area for about 25 years, and I've finally worked out that federalism is unnecessary. It's just not necessary. In fact, the only good thing about federalism is state of origin. That's the only good thing about federalism. But otherwise, we just don't need it. We just don't need it. And we certainly don't need it in this area. We need a national approach. And I'll just touch on something that I had some degree of involvement in, and this is based on some work that I've done in New South Wales. Now, many of you would be aware that the New South Wales Law Reform Commission prepared a report in 1996, authored by Professor Susan Hayes, on intellectual disability in the criminal justice system. Now, note, that was a state-based Law Reform Commission report, and naturally the people who authorised that report to be done had very considered and definite and well-considered objectives about what they wanted to achieve, and it was written by an outstanding scholar, and they made some great recommendations. And what happened to it? Well, there was a lot of discussion amongst academics about what needed to be done further, a lot of further research, maybe some bits and pieces of reform, but nowhere near enough work to deal with the issues. And so, not surprisingly, in 2001, Jim Simpson, along with a number of other intellectual disability advocates, prepared the Frameworks Report. So they said, well, look, if government isn't going to step into this space and develop systems for the management of intellectual disability in the criminal justice system, then we will settle those frameworks. And they developed a very comprehensive 120-page report that's known in New South Wales as the Frameworks Report, to develop a framework within which these issues could be developed. Now, I've specifically chosen a New South Wales example because I know you all hate me because we just won the state of origin, but also because I didn't want to tread into the Queensland area too closely, because that's what you are all doing, and I don't know enough about it. You know what you know about it, so I'm just going to talk about New South Wales, but it's a good allegory, really. So along comes the Frameworks Report in 2001, and then but then nothing's done. Well, not enough's done. So in 2004, the New South Wales State Ombudsman makes a report and says something needs to be done about this. There needs to be changes in intellectual disability in the criminal justice system. This is many years after that Law Reform Commission report. So they assigned that task to a senior officers group of a number of state government departments in New South Wales. And the issue drifts, and it drifts, and it drifts, and it keeps on drifting until 2008, when finally the senior officers group of these government departments in New South Wales come together and develop a protocol for how this issue ought to be dealt with and managed. But 2012, and we're back to the New South Wales Law Reform Commission for another blueprint about what needs to be done, because not enough has been done. Now, this is exactly the sort of bureaucratic history, if I might say so, that led to the NDIS, that led people to search for a national solution to this issue. And if any of what I'm saying about the history of this issue and how it's travelled in New South Wales is resonating with anybody here, then maybe I've made my point. Well, we all know that there's a very substantial amount of research that confirms that people with cognitive impairment are overrepresented in the criminal justice system. And I'm pleased that Leanne Dowse is here from the University of New South Wales, and she'll no doubt be speaking later about this topic. So I won't dwell on this. We're all aware of the statistics. They're not good. They're not good. And as I said before, this is only a partial description of some of the research that's been done. But incidentally, it illustrates the piecemeal and fragmented nature of the research that's conducted in this area. We just haven't got the evidence base that Jodie was saying we need across the country to deal with this issue properly. Now, this is all great research. You know, fabulous work has been done in this area, but it's piecemeal, it's fragmented, it's regional, it's state-based, it's territory-based. You know, we need a uniform national evidence base. We need to take this issue really seriously from a research perspective. Otherwise, we're not going to make the sort of headway that we need to make, because we know that this is a huge challenge. We know how diverse and complicated this challenge is going to be, but we need that evidence base, but we're going about it in a very fragmented way. And the reason, we all know why we need to have a proper approach to this on the research front, because prisons are horrible. And they are places where the weak and the vulnerable are threatened by the powerful and the mean. We all know why we need to do this. So we just need to have that thinking about the evidence base. So we need an informed approach. Do we know enough about practices in corrections and policing? Again, the advantage of being able to do a keynote is I can talk about the big issues. I don't have to descend into detail. I know that the detail is going to be covered by people here who know more about this stuff than I do. But I can just touch on these issues as we go. Do we really know what is going on in corrections and policing? Now, I know that there are people here from corrections and policing. I know that you've got a tough job to do. I know it's very difficult. And I'm only interrogating this issue from a researcher's perspective. Heather Douglas did some research on fetal alcohol syndrome disorder that was published on a website that I'll give you the links to in a minute. She's a fantastic criminal law researcher from the University of Queensland. But she wasn't able to do research within corrections because corrections wouldn't allow her to do that. Now, there may be any number of reasons for that. I'm not going to cast judgment on whether they were good reasons or bad reasons, but I note the presence in the Queensland Corrective Services Act of Section 132. Researchers can't talk to prisoners. We're not allowed to talk to prisoners. We can seek consent for that. Consent is withheld. So how are we going to do the research that needs to be done to build the evidence base and get the narratives of people's lives and trajectories and test people and get the sort of statistical evidence we need if there's that sort of legislative barrier there? Now, I am aware that there is an opinion that provision is constitutionally invalid, but, you know, would you really want to go down that road against any government in Australia, bearing in mind, and putting my lawyer's hat on for a moment, that the loser pays the winner's costs in litigation, including constitutional litigation. We've got this great system in Australia, constitutional litigation. You pay for the privilege of finding out if a government has obeyed the Constitution. I mean, we've instituted David and Goliath in our constitutional system. You just can't get remedies there. And believe me, I know, because as a constitutional lawyer, my record is terrible. Okay? I've consistently lost my constitutional cases, but to make matters worse, when you lose, you have to pay the winner. Now, that's just not the right system. It's just not the right system. So don't be looking for a constitutional solution to anything in this area. I'll reinforce that in a minute. So we've got this provision in the Queensland Corrective Services Act that is inimical to the development of the evidentiary base that we need to really deal with this problem. Now, we all know about the Avery case. I've taken the liberty of referring to Ms Avery by name. I know that her identity was anonymised in the Court of Appeal decision, but I checked with the Public Advocate this morning. Still no legislation to deal with this issue. Well, there's a discussion paper out about it, but it's 2014. You know, back in 2010 when this case was decided, you'd only won 5 state of origins, or 6. Okay, so we really need to get on top of this issue. I'm not going to dwell on this because there's going to be a talk about this this afternoon. We're all aware of what happened in that case. But as the Court of Appeal mentioned, it seems unsatisfactory that the laws of Queensland make no provision for the determination of the question of fitness to plead to summary offences. It's well documented that mental illness is a common and growing problem amongst those charged with criminal offences. The legislature may wish to consider whether law reform is needed to correct this hiatus in the existing criminal justice system. I mean, we're still waiting, so, perhaps something can be done. But there'll be a talk about this afternoon. So this is my whistle-stop tour of the issues. But it illustrates the need for a uniform approach because references to the mental health court cannot be made by magistrates in Queensland. So what's the problem? Is it just people don't want to reform this because there's an unwillingness to provide resources? Is there concern that this is just the tip of the iceberg and that this may become an issue that unravels and becomes too resource intensive? Or is it just a failure of leadership? Now, I'm sorry to be a realist. I apologise for that. I'm not an eternal optimist anymore. I'm an optimist, but I'm also a realist. And I think that we have to directly challenge the people who make decisions in this area to get them to make the decisions. We really do. Another issue, of course, that's I'm not sure is going to be addressed on the program, but probably will be touched on, is the issue of fetal alcohol syndrome disorder. Again, I won't go through these slides in detail. We're aware of the issues. We're aware of the fact that it's entirely preventable. We're aware of the fact that if children are assessed and diagnosed early in life, it's potentially treatable. And we're aware of the interconnection between the experience of fetal alcohol syndrome disorder and the criminal justice system in Australia. And the Aboriginal Disability Justice Campaign in particular has pointed out that there's a disproportionate number of Indigenous people who experience fetal alcohol syndrome disorder who end up in the criminal justice system. This is something that needs to be addressed. The costs are considerable, and it's something that we need to examine very closely. Getting back to Heather Douglas's research, she conducted research in September and October 2011 with judges and magistrates and lawyers to try and work out what their knowledge was of fetal alcohol syndrome disorder in Queensland. And the material's available on the FARE website, fare.org.au. And as the last paragraph of the slide indicates, they did try to get approval from corrective services and the police to conduct the survey. They were unable to get that consent. Now, I like talking to judges and I like talking to lawyers, but you'd have to think that's the attitudes and approaches that are taken by frontline staff in policing and corrections that are going to be absolutely pivotal to how this issue is managed. By the time, as a lawyer, by the time you get instructions from clients, there's been so much filtering of all the issues that you're presented with a client. Yes, this either you're aware that the client has an issue, or if you're not aware, you're in a position where you can generate the resources to find out, if you're properly trained, I might add. And of course, Heather Douglas discovered in her research that unfortunately most respondents had never heard of fetal alcohol syndrome disorder. They could work out from the words fetal alcohol syndrome disorder, they could work out what it is, but most judges, the overwhelming majority of judges, had never sent an accused person for assessment to confirm the diagnosis. And the most common reasons for not seeking an assessment was that the judge didn't know where to send the person to do that. Now that's a problem. That's a systemic problem that needs to be addressed. A smaller number, but still a significant percentage, said it would be pointless because it wouldn't change the result. Now, I don't know about you, but when I read that, I just felt thud. I just felt a thud when I read that. It would be pointless because it wouldn't change the result. And in fact, that's really what the Aboriginal Disability Justice Campaign is about, as we'll see. because it doesn't matter whether you're found guilty of a crime or not guilty because you're unfit to plead, you end up in prison. Okay. For those in the legal profession, it's the statistics are no better, and overwhelmingly, both professions said they wanted more information. They wanted to know what was going on. They wanted to be educated about this. They wanted to know where to connect people with services. They want to do the right thing, but are we providing the resources and supports in other part of the service system to allow the judges and the lawyers to do what they'd like to do in this system? Again, we acknowledge the limitations of the research because we weren't able to speak, Heather wasn't able to speak to police and corrections. And again, it illustrates the need for an informed approach, but all of this is quite obvious. Let me just turn to the topic of Aboriginal people in the criminal justice system for a moment. You're all well aware of the issues in this area, so I won't dwell on them at length, but we are aware, and the Australian Bureau of Statistics has done some work in this area, that the rates of incarceration for Indigenous populations is considerably higher than it is for everyone else, as it were. And so the Australian Human Rights Commission, not surprisingly, concluded that in light of all of these indicators, the Commission is compelled to conclude that people with disabilities have higher rates of interaction with the criminal justice system than other Australians. We note with grave concern the high rate of disability among Aboriginal and Torres Strait Islander peoples, and that they are overrepresented in Australian prisons. Okay, and this is a consistent theme that's been with us as long as statistics have been kept. So what is the Aboriginal Disability Justice Campaign? This is where I want to land and spend some more time talking to you. And I should indicate, by the way, that if you want to stop me and ask a question at any point in time, feel free. So just, sort of shoot up your hand and say, hold on, what about this? But I'm going to leave some time at the end for questions as well, if you have any. Well, the thrust of the work of the Aboriginal Disability Justice Campaign, which is mainly the work of an advocate named Patrick McGee, who unfortunately can't be here today. He was going to come, but he's got a tummy bug, so he's back in Sydney, taking care of himself there. Patrick McGee and also Ian McKinlay. They're guardians of Aboriginal folk in the Northern Territory who have seen this pattern over a number of years. And if you Google Aboriginal Disability Justice Campaign, you'll come up with a bunch of links to the sort of work that they're doing. They've been engaging with various advocacy groups around the country, various academics and lawyers to provide them with advice and what have you. And as we'll see in a few minutes when I talk about what they've been doing recently, you'll see that they've, as an advocacy group, they've been gathering some steam. So the basic issue that the Aboriginal Disability Justice Campaign is concerned with is that Aboriginal people with cognitive impairment are charged with crimes. They're brought before the courts, where the court finds that they're unfit to plead. And then the court, under legislation that in broad measure is similar in each jurisdiction in Australia, makes a custodial order or a supervision order. And in some jurisdictions, some more than others, there are no secure psychiatric beds available or an insufficient number, and so they are imprisoned, detained in a prison, as that expression is used. And the fundamental problem with this, other than the fact that they shouldn't be in a prison at all, the additional layer of injustice here is that they end up staying in prison for longer than they would have if they'd been convicted of the crime. So it doesn't matter if they're found guilty of a crime, go through a criminal trial, prison, not guilty by reason of mental incapacity, prison. And they're in prison for longer than they would have been if they were convicted of the crime and given the maximum sentence. And this is going on in Australia, folks, all around Australia, although less so in some states, it has to be said. Now, unfortunately, I was going to show you some video of a late line excerpt about Rosie-Anne Fulton, who's in Kalgoorlie, and she's been in Kalgoorlie prison for a lot longer than she ought to have been, and some media attention was brought to this issue on the 13th of March, And there are 8 officials now of the Western Australian and Northern Territory government who are all working together to try and get Rosie back to the Northern Territory, which is where her homeland is. 8 people are all... I understand that they're even arranging for an airplane to go and pick her up. Now, I think about 8 people and all the resources that entails for that one person, and I think that's fabulous. But again, there's a resourcing issue there, isn't it? So maybe if we took a more considered, evidence-based, national, structured approach to this, maybe we could actually save money in how we deal with this issue, rather than putting out spot fires that come to the attention of people nationally and then are dealt with as spot fires. Well, I anticipated cleverly, and also because I've got 20 odd years experience giving talks, that there wouldn't be an internet connection for today. So I've included some transcript, which I'll get to in the next slides. But I was going to also show you the Senate resolution. The Aboriginal Disability Justice Campaign, to their great credit, after the Late Line interview, went to the Senate, and they got the support of every senator in the Senate. Liberal, National, Labor, Greens, Xenophon, everybody who was in the pre-1 July Senate passed a resolution that was put by Senator Seward of the Western Australian Greens that something needs to be done about this at the national level. And that followed a social media petition that was conducted under the auspices of change.org, which received over 200,000 signatures in 7 days. So there is a constituency for reform, folks. There are people out there who want to see reform in this area, who are prepared to support reform in this area. And you can get immediate national attention to an issue, and you can get unanimous Senate support for an issue. It's just a question of, well, how do you get to the next spot? How do you get them to consider legislation? We have sent them legislative standards, legislative principles to consider. We have been given an undertaking that they're going to be referred to Parliamentary Council, but we need to watch this space and focus our energy on keeping this issue going in the coming months. Now, it's a shame I can't show you the video from the Senate resolution, because the Minister for Aboriginal Affairs, Nigel Scullion, did give a short speech, and he responded favourably to the advocacy of the Aboriginal Disability Justice Campaign for the management of this issue, for dealing with this issue. But he indicated at the conclusion of his speech to the Senate, he said, "I've written to the Attorneys General of Western Australia and the Northern Territory to try and generate a solution to this issue." Now, I don't want to be cynical, but I'm a little bit concerned again about that issue of the federal government saying to 2 states, "Oh, deal with this issue," because it smacks of that classic buck passing that has been the history of the disability service system in Australian federalism for decades and decades and decades. And with the criminal justice system, you've got the same recipe for failure. And that's why I'm concerned about the comment that Graham Innes made in the Equality Before the Law report. Not because I think he agrees with it. I don't think he does. However, I'm concerned about how federalism can operate in this area. And so I wanted to show you that video, so it's a shame I can't, but there you have it. What can the federal government do? Is it really just a matter for the states and territories? Well, there's Graham's quote, just to remind us. But the national government can do something. It actually can do something. It's got the constitutional power to do something. So if you open the Constitution and you go to section 51, subsection 29, they use Roman numerals, so it's XXIX. Section 51, subsection 29 of the Constitution gives the federal parliament power to make laws for the peace, order and good government of the Commonwealth with respect to external affairs. And the High Court has said in a robust jurisprudence, there's lots of precedents for this, that the Commonwealth can implement international treaties into domestic law. And you know what? Of course they can do it. Now, I know that historically and politically, there's been a little bit of a division of opinion about whether the Commonwealth Government should implement international treaties into domestic law. So concerns expressed by the states and territories about what they saw as the creeping tentacles of Canberra and a propensity to implement international treaties into domestic law during the 1980s there was a reaction to that. And in the early years of the Howard government, there was a consultative committee, so the federal government would consult with the states before they implemented international treaties into domestic law. It didn't stop them from doing it, mind. And really that concern mainly came from Queensland. So I don't know how many of you remember, but certainly in the 1980s, there were lots of environmental development projects that were going ahead in Queensland, but there was a federal Labor government in Canberra which at various times, with Greens' preferences, was anxious to ensure that international environmental covenants and conventions were properly realised within Australia, and that included Queensland. So if you study constitutional law, you would know that right throughout the 1980s, there's all of these external affairs power cases that involve the Commonwealth and Queensland and the Commonwealth, okay, because they were at war with each other during the 1980s. And the High Court ultimately established that you can use the external affairs power to implement international treaties into domestic law. You can do that, and there's substantial authority for that. Now, as I mentioned at the start of that little stanza of the talk, the Coalition has traditionally resisted doing that, but you know, if you look at it a bit more carefully, they say that they resist doing that, but in fact they do that. And the classic example, folks, was work choices. The work choices legislation, which the Howard government implemented in 2006, which caused ultimately their political peril, involved the implementation of lots of international treaties and conventions. Lots of international labour organisation conventions. So every government, whatever their putative and public posture is about implementing international treaties into domestic law, they all do it, and they all can do it, and there's plenty of authority for it. So there can be a national approach to this. In fact, the NDIS is the classic example. Although it should be noted, folks, before you get too excited, the Objects Clause in the NDIS legislation makes it clear that the United Nations Convention on the Rights of People with Disability is only one of the themes in that legislation. And if you read the legislation carefully, you'll see that it's not a holus bolus implementation of the UN Convention on the Rights of People with Disability. There's plenty of wriggle room for lawyers to work around the convention, especially when it comes to funding of packages. So before considering the prospects of a national approach, what are the prospects of exploiting the convention to achieve improvements? And I did tell you that I'm a sceptic. I've included some notes about the convention. It's about the advancement of human rights. It's about taking all appropriate measures, including legislation to modify or abolish existing laws. It's about the advancement of human rights. So it says all the right things. And in fact, it goes further. The United Nations Convention on the Rights of People with Disability was drafted in a way that acknowledged Australia's egregiously awful record in implementing its international obligations under human rights treaties. Sorry, but it's just true. We were aware of that. And when the Australian lawyers went to negotiate this, they included provisions that said something needs to be done. And you can see the legislation's not just symbolic, it's programmatic. It's designed to be implemented. It's about taking all appropriate measures, including training. And not just the judges and the lawyers, but police and prison staff. Article 13.2, getting back to a point I made earlier. And Article 14 and Article 14 of the UN Convention uses the same language as Article 9 of the International Covenant on Civil and Political Rights. Just want to spend 5 minutes talking about that because it's significant. Article 9 of the ICCPR says that no one shall be subjected to arbitrary arrest or detention, and that they have a right to go to court to have their arbitrary arrest or detention questioned, challenged. The jurisprudence of the United Nations Human Rights Committee has stressed that the concept of arbitrary detention encompasses detention that's inappropriate, unjust, unpredictable. So we can't engage in arbitrary detention in Australia. Unfortunately, the relationship between Australia and the Human Rights Committee, which is the monitoring body under the ICCPR, it essentially involves a decoupling. Okay, so Australia signs international treaties, they say they're going to commit to human rights, and then in the litigation that you engage in the United Nations Human Rights Committee, they decouple Australia from those international human rights obligations. Even rich, developed liberal democracies like ours can pursue a policy of deliberate and persistent non-compliance, which means access to international justice is meaningless. Sorry to say. A classic example involves an Aboriginal man, Ken Tillman, who I represented in a communication to the United Nations Human Rights Committee. It was filed in 2007. It was determined in 2010. We're aware of the fact that there's legislation in Queensland and a number of states that authorises the imprisonment of sex offenders after the conclusion of their prison sentence. It's done by way of a civil trial, so it's not a criminal trial. The argument underpinning that legislation, or the argument that Mr. Tillman put, is that imprisonment is punishment. It can only follow a criminal trial. And Mr. Tillman himself said, preventive detention of sex offenders, preventive detention of asylum seekers, preventive detention of people with mental health issues, preventive detention in all of these contexts may be warranted in some circumstances. May be warranted in some circumstances. Now, it's a heavily qualified statement. But the argument here was that can't be undertaken in a prison. This is how the Australian government responded. The complainant argues that the mere fact, this is a mere fact, folks, just a mere fact, the mere fact that the detention takes place in a prison gives it a predominantly punitive character, and that detention would need to take place in a special mental facility or hospital to avoid this. The Australian government submits that this is not the case. The complainant has access to the best available rehabilitative resources and facilities within the prison system. This enables the government to achieve the dual goals of ensuring the safety of the community through detention in a secure facility and rehabilitation by providing the individual with the most appropriate therapy. Now, I could tell from the reaction to that you think that's rubbish. So Australia's position, let's just boil it off. Prison is not punitive if it's undertaken for non-punitive purposes. Now, I've read 1984. I've read a bit of Franz Kafka. Okay, that just looks like doublespeak to me. And the Human Rights Committee formed the same conclusion. And in an 11-2 ruling, they said that imprisonment is penal in character and cannot be ordered following a civil trial. Now, this doesn't just apply to the sex offender legislation. This applies any time the Australian government or any state or territory government is placing someone in a punitive environment, in a punitive detention environment. But this was the Australian government's response. In relation to less restrictive means of rehabilitation, which was what was argued by Tillman, the New South Wales government has advised that in imposing a continuing detention order on Mr. Tillman, the New South Wales Supreme Court was satisfied that at the relevant time there was no treatment available in the community. So they respond to their international obligations by saying, but the Parliament of New South Wales and the courts of New South Wales have told us that there's nothing else they can do. Now, that's just a ridiculously passive approach to these international obligations. The non-existence of the facilities or the alternatives, the facilities that people could use for therapy, that's the issue. But the government's response is to rely on that, to rely on the very shortcomings of the system as somehow overruling the Human Rights Committee's decision. So legally unacceptable practices are projected as realities that can't be overcome. Yes, but they just told us that that's what they do. I mean, come on. This is an extraordinarily constricted vision of how international legal obligations are to be translated to concrete circumstances. It's just passively circular. And the passive circularity of the content of the response, it just reflects this distancing that the Commonwealth engages in. You say, it's a federalism matter. There's that federalism problem again, which are, of course, not recognisable under international law. In international law, they don't care if you're a federal system. you're expected to implement it. And of course, the final insult was on the 25th of March 2013. This is, note, 6.5 years after the communication has been filed. So look at the slowness of this system. And then to get this result, where the Australian government said, after they were prompted by the Human Rights Committee to respond, said, having considered the submissions from the parties, the government did not consider further action is necessary, and it now regards the communication as finalised. That's the Australian government's response. Oh, we've considered the submissions and that's it. So that's it, apparently. So sorry to be cynical, but I think international obligations tend not to be pivotal in these debates. What we need is to actually look at services and what's needed, and I share the Equality Before the Law report does this exceptionally well, but of course so did the Frameworks report back in 2001. So did the New South Wales Law Reform Commission report back in 1996. And this is drawn from the ADJC position statement, which is available online. We need cross-departmental responsibility. We need accommodation and support programs, both as an alternative to prison and post-release. We need it to be treated as a last resort. We need skilled intervention. We need mandatory review of orders. We need these things, okay? And I'll leave the slides with Mark if you want access to them. There are practical alternatives to the current approach, and certainly in Victoria and New South Wales, there are ways around this. Again, I'm studiously avoiding Queensland, even though it's in the title of my talk. You're better placed than I am to make an assessment. The last thing I was going to do was inflict a speech by Tony Abbott on you. You know what? This is actually a really good speech. I was genuinely impressed. Note the date, 13th of March 2013, which was exactly a year before Tony Jones from Lateline interviewed Warren Mundine, the chair of the Prime Minister's National Indigenous Advisory Council, about the issues that I've been exploring in my talk today. And in his talk, I anticipated that the link wouldn't work, but I've drawn your attention to where you can see it. This is what the Prime Minister said. He said he wants a new engagement with Aboriginal people. He said that health, education, employment and housing standards of Aboriginal people have fallen lamentably short of those of their fellow Australians. He said that this initiative would start at the top of the government. He said that he would be a Prime Minister for Aboriginal affairs. He said that Aboriginal people will be at the heart of the new government in word and in deed. He admitted that it would be presumptuous, even arrogant, to think that an incoming government could swiftly overcome 2 centuries of comparative failure, but he said that if they didn't do it, they would be negligent. And then he said this. He said, a flurry of activity from a new government lapsing into business more or less as usual won't be good enough. A new cycle of enthusiasm turning into cynicism will not do. That's what he said. Do we think anything will be done? I'll leave that question out there in the air, but I'd just like to close off by acknowledging that it would be cheaper. Maybe that will cut through. The human rights arguments don't cut through. They haven't cut through, really, in many, many areas. So maybe we should just tell people it's cheaper, because it is cheaper. It's cheaper to invest now. It's cheaper. And Jodie was speaking about justice reinvestment earlier, and other people will be speaking about that, so I won't dwell on it. The Australian Human Rights Commission has also acknowledged that this is an approach that needs to be taken. We will save money if we do this. So even if the human rights issues can't cut through, let's at least be efficient and save money and develop these systems so that we can assist people. Because after all, as the Australian Human Rights Commission noticed, the human costs of victims and their families and offenders and their families is something that needs to be addressed. So to sum up, I think we need a national approach. I think we need an informed approach. I think we need a uniform approach. I don't think the international obligations are pivotal, and we need political leadership on the issue. So thanks very much for listening. Has anybody got any questions they want to ask? There was a little bit of uncomfortable shifting in seats when I was speaking, I noticed. So if anybody would like to...
comment, Patrick?
Thank you very much.
Really just on your last point about expenditure, whether it's cheaper, and often it seems to be my observation that there's money to be spent when there's political will. So it seems to be for governments to spend on prisons and increasing the prison population. That seems to be sort of an acceptable political reality rather than looking at saving money in certain areas. And I think that's a problem in terms of actually having that discussion with government about those sorts of issues. It's okay to build more prisons, but it's sort of not okay to have programs which may assist people.
Yeah. Well, I think I think you're quite right, and I hope I didn't come across as naive in not referring to those issues or addressing them in my talk. But I've met a lot of police and a lot of people in corrections, and almost invariably I've found them very dedicated, serious people who want to do the right thing and address the work that they do with great care and consideration of these sorts of issues that I've outlined here, but they're not being placed in a position where they can do that. I acknowledge the persuasive power of penal populism and the fact that crime prevention is very attractive, and that substantial parts of the media are very supportive of that agenda and what have you, and that makes it difficult for politicians to incline to a different point of view. But there are other places and other spaces where this sort of debate and consideration has led to political change. So the Western Australian government, incidentally, recently has directly addressed the Aboriginal Disability Justice Campaign issues that were raised last year. They've recently, the Office of the Official Visitor, who visits the prisons, has published a report in this area. There was draft legislation that was tabled in Parliament in the Western Australian Legislative Assembly last year to have limiting terms to ensure that people aren't incarcerated for longer than they would have been if they were convicted of the crime in a criminal trial. So there is an addressing of these issues in some jurisdictions, in some places, I think that sometimes political leaders can surprise, it strikes me that within Queensland, and again, apologies for the state of origin victory, and any Queenslander listening to this will immediately stop listening. But it does strike me that the state government is in an excellent position to show leadership in this issue, in respect of this issue in Queensland, precisely because of their 77-seat majority. So it cuts both ways. It's not just about this is an issue that the government may not want to touch, but it would be cheaper to have justice reinvestment now to deal with this issue, and the majority gives them the political clout and the political capital to actually do something that's really good. I started that answer by saying that I didn't want to sound naive, and I ended by sounding naive. So, any other questions? Yes, Leanne.
You've given us a fantastic example of the Aboriginal Disability Justice Campaign, but it would be really good to get your sense. I know you've been involved in it for quite some time, and I'm sure other people have sort of come in and out of it. It's been extraordinarily effective for particular reasons, I think, one of which is, a couple of really passionate people kind of got started. So if you could just say something about what the nature of activism that's necessary to sort of get some change. We can talk about issues, but also this is beyond sort of an issue around Aboriginal issues, So what are some of the hallmarks, I suppose, of activism which could potentially bring together organisations like Endeavour, researchers, government agencies? What are the key things that are going on that make that one so successful?
Okay. Well, I wasn't anticipating that question, so this will just be off the top of my head. But so the question, for the benefit of the video, was around what are the hallmarks of effective activism in this area, because the Aboriginal Disability Justice Campaign is an example of, I think, of its activism with some effectiveness because of the Senate resolution and the fact that the Senate is now considering the legislative standards that have been developed by the policy team, including Leanne, I might add, Leanne Dowse from the University of New South Wales. Look, just reflecting on what Jodie was saying earlier, I'm not sure if she used this expression, but certainly it came through in her talk, tenacity. So extreme tenacity. I mean, Ian McKinlay and Patrick McGee, who are the co-organisers, coordinators of the Aboriginal Disability Justice Campaign, are absolutely passionate about this issue, and they've just expended enormous personal resources and reserves into this campaign. I mean, it's I've never met, you rarely meet people with that sort of passion, and I do hope that they can realise their objectives, because they're extremely worthy, as I think you'll all agree. So tenacity. They're well connected, I think. So they've reached out to connect with scholars like yourself, and with non-government organisations in the states and territories, like People with Disabilities in New South Wales, and the First Peoples Network, also in New South Wales, to create those institutional linkages which are likely to leverage high quality outcomes and effective outcomes. They've been reasonably good at hoovering up small amounts of resources to keep things going, to keep the home fires burning, as it were, although they could certainly be more adequately resourced than they are. They're supported by groups of like-minded folk. So Jodie was reflecting this morning in her context, providing opening address about the need for all of us to come together and invest our intellectual resources and energy and knowledge into developing the sort of solutions that we'd like to see, and the ADJC is actually doing that for that particular issue. And then one remarkable piece of work they've done is they've been in touch with a very effective media organiser, Sarah Irvine, who's connected them with new and powerful social media operations like change.org that can shoot up into the heady atmosphere of Canberra politics. Hey, we've just got a 200,000 signature petition here. Because when you're talking about those sorts of numbers, and I was reflecting on the 144,000 people with impaired capacity in Queensland statistic that Jodie was talking about earlier, and that's a lot of people. I mean, I suggested over the morning tea, it'd be really interesting to get that 144,000 people in Queensland. I know it's a projected figure, there's less now, but it'd be really interesting to get that figure and map it over electorates in Queensland. That would be a really excellent piece of research, because I understand there's been recent research that the Federal National Party is very interested in around the number of beneficiaries of the paid parental leave scheme if it's implemented. And apparently in some electorates held by members of the Federal Liberal Party, there are more beneficiaries than there are people in the National Party seats, whose businesses are maybe structured differently, or the partner who's staying at home with the children may not be employed, or what have you. So there's a bit of concern around that, and that's exactly a way of, it seems to me, the numbers issue, and the numbers issue was big in the NDIS. There's so many people around Australia saying, finally something's going to happen at the national level. The numbers issues were always big in the disability space. There are always hundreds of thousands of people affected, and hundreds of thousands of people in families with people with disability. The numbers are there. So I guess getting back to your question, Leanne, social media. People just think, social media is something you do when you want to find out what Kim Kardashian is wearing, or something like that. No, it's actually a really powerful thing, because it's given everyone an opportunity to get the sort of to have the sort of political clout that's really needed in this area, and the Change.org petition propelled that. So I'd say that's another critical differentiator. But I hope that answers your question. Okay. Okay, I know as Queenslanders you're probably getting sick of hearing a whiny New South Welshman. So thank you very much for your for listening and for your questions, and I'll be here if you'd like to bail me up and talk footy or disability.